welcome to this policy dialogue on tough love towards a more assertive EU trade policy, which has been organized jointly by the European Policy Center and Egmont. We're very glad to welcome Denis Redonnet, who is the Deputy Director General of DG Trade, but also the Chief Trade Enforcement Officer. The first time we have had that role, so we're looking forward to hearing more about that. Clearly, this is an area where there has been a lot of turmoil over recent years, with some trade disputes between economic partners, some global instability, and with multilateralism not functioning as well as it should. There has been this call for making trade policy have more teeth, to be able to enforce the kind of agreements, the kind of rules the European Union has agreed to. So we have had this innovation of a new rule, and we're looking forward to hearing exactly what is going to be in that rule and how that is going to develop over the coming years. The presentation by Mr. Redonnet is going to be followed by two short interventions, and I'll introduce the panelists at that point. But we will also have time for a discussion with the audience. So if you do have any questions, there are two ways you can ask those. Either write it in the Q&A box. If you write it in the Q&A box, please keep it short, otherwise it's difficult to take it into account. Or the other option is that you raise your hand virtually, and then I will try to get to you in the discussion. But without further ado, we'll start with an intervention by Monsieur Redonnet.
Thank you very much, Ferdinand. Thank you very much for giving me this opportunity to sketch out what we're doing at the moment in this area, this part of the common commercial policy, and have a chance to interact with the stakeholder community. It's much appreciated. When I was looking at the title that you gave to the event, I was intrigued a bit by this notion of a more assertive EU trade policy. I think maybe we should start by defining terms a bit. If by assertive we mean that as a trading bloc we need to assert our rights under international economic law in general, including inside the international trading system with the WTO at its heart, certainly. I think if it suggests something different, where we would somehow have a more aggressive, protectionist, or punitive approach to trade policy, I don't think that's the case. I think the focus right now is to try collectively in the Commission and beyond the Commission, I'll come to this in a minute, to try to mount a sort of renewed effort and take additional new steps to ensure first and foremost effective implementation and enforcement of our trade agreements, our trade arrangements. And enforcement in the sense of compliance, I think is the right word. And to do this, basically, we'll try to do this better and faster as well. And so I think it corresponds to really three things which are slightly different. One is about maximizing the potential benefits of the trade agreements that we negotiate, ensuring first and foremost that take-up by stakeholders and interested parties. And that includes doing this by activating also the cooperation frameworks that these trade agreements and arrangements provide. It's about tackling market access issues in third countries. And it is, yes, also about ensuring proper compliance of legally enforceable commitments and obligations under these treaties or under these trade arrangements when they're not trade treaties per se. I think there's also an element of context in this, which is perhaps worth recalling. And You would have seen that this is something the Commission has also expressed when it launched the trade policy review, which is ongoing and which will lead to a statement of policy by the Commission at the beginning of next year. I think there is a sort of degradation of the environment against which we deploy the common commercial policy right now and has been going on for a few years. I think you can list very succinctly the following elements, which I think are relevant in this context. First of all, we are going to operate trade policy in the context of the economic crisis that is linked to the pandemic. And that will have impacts in terms of greater demands for protection and possibly greater demands for government intervention in the economy in many jurisdictions. And that in itself is potentially difficult to manage in terms of impact on international trade. Second, I think there are tendencies worldwide towards more protectionism. There are unresolved level playing field imbalances in the international trading system and structural distortions that are there and that color the environment in which we operate common commercial policy. I don't think I need to go into great details on this, but there are issues, including, I think, the insufficient absorption of state capitalist policies in the framework of international trade rules today. And then we're seeing also a phenomenon of what some people have called the weaponization of trade, more aggressive forms of unilateralism, this kind of mix between geoeconomics and geopolitics, and some of the tensions between some of the big trading players. I'm thinking in particular here about the tensions between the US and China, which has a knock-on effect on the international trading system. And all this in an area or at a time when the whole connection between trade, technology, data, national security considerations, of course, creates a more complicated cross-silo set of issues about international economic relations. And finally, all this in the context of an erosion of the multilateral rules-based trading system with the WTO at its heart, because in the WTO today, you've got on the one hand the dysfunctioning of the dispute resolution arm because of the impasse of the appellate body, and a certain stasis of the negotiating function in the WTO. It has to produce new rules to keep up. So in this context, I think the question is really what kind of path do we try to chart as European Union, as one of the big trading blocs? I think to be assertive, we have to be, on the one hand, determined about using the instruments that we have, and disciplined. And the more disciplined we are, the more determined I think we can be in terms of deploying our tools. When it comes to being determined, I think the basic principle is where we have clearly enforceable commitments and enforcement frameworks, then we should use them. And there, I can take the example of recourse to dispute settlement. The use of the dispute resolution frameworks that we have per se in our trade agreements, recourse to them is not necessarily a bad thing. Recourse to third-party adjudication is a fairly civilized way of resolving disputes between states in international economic relations. The contrary is more problematic. And that's why we have started to take dispute settlement cases, not just in the WTO, where we are and continue to be a normal user, I would say, proportionate to our size in global trade, but also now in the context of bilateral agreements, where we have now, after a long time where these frameworks were never used, for dispute settlement cases under the bilateral trade agreement. And we have a certain doctrine, if you want, of use of this. I mean, we do prioritize cases. We have a logical set of criteria to apply. We look at whether we have legally sound cases, economically important and relevant cases, and things which we pursue because they have a systemic dimension. We've set this out, by the way, recently in a notice which you find on the DigiTrade website, which sets out a bit the sort of working approaches that we try to follow on trade enforcement. And on the other hand, disciplined. I think that's very important. Whatever we do, we have to remain anchored in the rules-based trading system per se. I think that applies, for example, to how we deploy trade defense instruments, the classical trade defense instrument in the sense of anti-dumping, anti-subsidy, they're WTO compliant. I think we have a good system in the sense that we have scrutiny over them, but we have a relatively good record in terms of our measures being challenged. We have a system which is pretty effective. If you look at our annual report on trade defense instruments, and when we use the instrument because we can use it, it does play its normal role in terms of curbing distortive imports. Where necessary, we do test a bit the boundaries and the limits of the system, and we've now started to go after what we call transnational subsidies. So subsidies in third country jurisdictions, even if they come through more complex routes, I would say. And we are going to be very attentive going forward, making sure that the standards that we apply to ourselves are met by other jurisdictions as well, including when there is trade defense that is being applied by third countries vis-à-vis EU interests in third countries. Now, this being said, we need to complete the toolbox. We needed to complete the toolbox, and there's a process ongoing for this. Completing the toolbox, I think we can look at this in two ways. First, in the sense of adding a number of new legal instruments, but also, and not only that, in terms also of upgrading, I would say, some of our practices and approaches. So in terms of the toolbox, in the sense of legal instruments, there have been quite a lot of developments recently, and some other initiatives are on the way. We have modified and amended, we are about to amend the enforcement regulation, the trade enforcement regulation, the unilateral statute that enables us to take countermeasures in trade. And we've done that in order to add, if you want, a sort of final line of defense against the possible paralysis of the WTO dispute settlement system. We have engaged with a number of countries into setting up this multi-party interim arrangement that would enable us to have proper two-step adjudication with those that want to, but we also are giving ourselves the means through the enforcement of the regulation to ensure that we cannot be, if you want, frustrated out of our rights to proper adjudication of trade disputes. And that's a very fundamental principle. And that's both in the WTO context, where we have a problem with the functioning of the WTO today, but also in bilateral dispute settlement frameworks. And the power co-legislators have also extended the remedies available under the enforcement regulation beyond goods, as you perhaps know. The Commission has also indicated it would take forward a proposal for a possible anti-coercion trade instruments, so to sort of deal with possible attempts by third countries to interfere through trade measures in our domestic affairs, and that would be based on international public law. You know also that there will be a proposal for a new instrument to deal with distortions from foreign subsidies in the internal market, to the extent that those are not tackled well, because there is no importation of goods, which is what trade defense instruments allow you to tackle properly. You know that there are proposals for an international procurement instrument with respect to a greater reciprocity in public procurement. And we have also upgraded and are operating a new EU coordination frameworks for, on the one hand, foreign direct investment screening, and on the other hand, export controls, of dual-use goods and emerging technology. So if you want this range of initiatives on the legal side, taken together, I think they correspond to a pretty serious upgrading of the legal instruments. Of course, all this cannot be achieved, proper trade enforcement, and leveling the playing field cannot be achieved exclusively through development of unilateral tools. It's very clear that part and parcel of this effort is also for the EU to try to get more and better global rules, including in the WTO. And this is why WTO reform will remain a very, very central policy objective for the EU, in order to, again, make sure that we can anchor and assert our rights in the international economic system. But as I said, it's not just legal treaty type initiatives that we've got to take. And I will finish with this. We're also looking at improving some of our practices and our processes. And I would say on the continuum between implementation and enforcement. So on implementation, on this question of the take-up of our trade agreements, we're putting forward new tools. Central new tool for this is the new access to market platform, which we have now, which is now in operation, and which is about providing as much accessible information to make sure the awareness of the possibilities of trade agreement is there and lower the information costs associated with this, including on some of the more complicated aspects, if you want, of our trade agreements. I'm thinking in particular about the question of rules of origin, which is clearly viewed by stakeholders as one of the difficult elements to navigate in our trade agreements. But also by simply, I would say, reviewing internally how we inject energy and life in all of the implementation structures and committees that we have established under the trade agreements, where we have bilateral trade agreements in particular. And what can we get, and can we get more out of this engagement with third countries under the frameworks of implementation of the trade agreement? You know, we know we have things that work, where we solve issues through committees, and in some cases work less. We've got to try to draw lessons and emulate what works well. And on the enforcement and compliance side, and you mentioned this at the very beginning, we have now set up a new single entry point for receiving complaints from stakeholders, all EU-based stakeholders, for us to receive complaints relating to market access issues and breaches of commitments in agreements across all aspects of the agreements, including, for example, on the sustainable development related commitment of our trade agreements, under the TSD chapters of the FTAs, or under the GSP. And the idea there is basically that we try to organize ourselves in such a way that we can be very much evidence-based in the way we tackle market access issues and compliance issues with trade agreements. So we're trying to organize the way in which we absorb the evidence gathering that will come from member states or stakeholders that will enable us to act as Commission, and at the same time to be, we hope, more responsive to the stakeholder community in the way we do that. It's not just a complaints-based approach to trade enforcement. We also have the possibility to act in all these matters of, let's say, compliance with our trade agreements in an ex officio basis under our own administrative powers. And we have indicated that we will reserve the possibility to do that. For example, to do the discovery process for evidence building in these areas in a structured manner, perhaps mirroring for example, under another enforcement instrument, which is the trade barriers regulation. In particular, when, for example, we're dealing with situation where there may be concerns about retaliation from third countries, or when we are dealing with market access or compliance jurisdictions which tend to be intransparent and difficult to penetrate. So just to finish off then on this very broad kind of overview of the different areas of work, if you want, and strands of work that we're taking forward right now. I think that there are two important things to keep in mind. That I think we understand that the governance of all this matters, and so it's got to be understood. It's got to be accessible by stakeholders, and so a big part of what I have to do is also to make sure that this is known and understood by the stakeholder community, and that we report regularly. So report to the political authorities in the system under which we operate, in particular the European Parliament, not just the member states, but also the European Parliament, and that we provide a sort of structured dialogue with the stakeholder community. And we have, for this, we're going to use the instruments that we have in place. For example, the civil society dialogue framework that DG Trade has with its, would say, trade stakeholder community. And the second thing is that it's very much a collective endeavor. So it's not a pure DG Trade effort, if you want, in the Commission, but it's something which requires a lot of mobilization and organization, both with the European Commission and the Commission services as a whole beyond DG Trade, because most of our issues now relate to a whole slew of other policies and not just classical trade issues at the border, so it requires work internally in a different manner, and beyond the Commission, because obviously on implementation, we have to partner with the member states' national authorities, because a lot of the implementation is done in a decentralized manner, if you want, contrary to the negotiation side, and with stakeholders directly. So, you know, if you have to sum it up, I think we're tooling up, but of course the key is to tool up, but use the tools wisely, and that's the balance that we're going to try to navigate going forward in this renewed effort. So that's perhaps hopefully gives for the people who are on the call a sort of overview of where we are as of end of 2020 on this effort. Thanks.
Thank you very much for that overview. Very helpful tour de horizon, and I think there are a number of issues there to pick up. So we'll start with Guillaume van der Loo, who is a research fellow both at EPC and at Egmont, with some initial reactions. And after the two reactions, I'll also come back to you to have any responses to those. So Guillaume, please.
Many thanks, Fabian. Indeed, Mr. Redonnet has covered a lot of ground and a lot of these new instruments or modernization of existing instruments. So I will try to pick my battles and comment on two issues that were already mentioned, and add actually one more issue that remained a bit under the radar so far. So first, very briefly, in relation to enforcing EU and international trade rules at the level of the WTO. Here, I mean, it's important to note, obviously, that although there is the dispute of the appellate body, the issue of the appellate body, that the WTO system is not completely in limbo. I mean, the EU is still involved in several cases at panel level, and obviously we also have now the multi-party interim appeal arbitration in place between a dozen of countries. And there it's important, for example, to note that also China is on board, and for example also China has supported and aligned with the EU's proposals for WTO reform. So there is a bit of a, I mean, it are not only like-minded countries that are aligning with the EU to reform the WTO appellate body, but obviously, I mean, the key trading partner that is not on board is the US. And you can argue in a perfect world that you can say, okay, the EU can team up with China to get the US on board on a reform on the appellate body and the dispute settlement as such, and that the EU can team up with the US to tackle the shared concerns in the WTO that they have vis-a-vis China, which regard to subsidies, state-owned enterprises, and so on. But obviously, I mean, the concerns that the US has vis-a-vis the appellate body will most likely also remain under the Biden administration, because of course, as such, that is not really new. But I wanted to pick up on one issue, or mention or focus on one issue, which is the enforcement regulation, the bazooka that Monsieur Redonnet has mentioned. So this is now modernized so that the EU is also capable to retaliate and take countermeasures when a dispute is stuck at panel level, or also in the context of bilateral trade agreements. But there are some concerns that maybe the EU is going a bit too far. I mean, in that sense, that obviously there are good reasons why the EU is modernizing the regulation in the sense that as it happened. But you see also, for example, now that the EU also will be allowed to include services and issues related to intellectual property rights to countervailing measures. And there are some concerns that the EU is actually could maybe harm the very issue that it wants to protect, that is a rules-based system. And this in particular could be the case, or I mean, there's the danger that this could happen in the context of this new anti-coercion mechanism that the EU will propose next year, and that was already mentioned. So there, I think it will be crucial that the EU will make sure that, I mean, this mechanism is proportionate and avoids that it's a punitive instrument, and obviously that it is also WTO compatible. So actually, I would like to hear a bit more from Monsieur Redonnet how this anti-coercion mechanism, I mean, would look like. Now, secondly, a very brief comment on the enforcement of trade rules under bilateral trade agreements. Indeed, I mean, you see, whereas initially the EU didn't really use dispute settlement mechanisms under bilateral trade agreements. Recently, we have some cases with South Korea, Ukraine, South Africa, Customs Union. But there is actually still a lot of work on that front. If you, for example, look at the 5 most important trade partners of the EU, such as the US, China, the UK now, Switzerland, Russia, Turkey, the EU doesn't really have a free trade agreement with them, or not a free trade agreement with a really strong dispute settlement mechanism. So there, I mean, there remains, there is still some work to do. Or if you, for example, look at the recent trade barrier report, the top 5 countries with the highest number of trade barriers are China, Russia, Indonesia, again, US, India, and Turkey. And again, with these countries, the EU really doesn't have a strong FTA framework, or in any case, an FTA framework with a strong dispute settlement mechanism. And although, I mean, there are some, there are negotiations ongoing with China and so on and so forth, but I mean, it remains to be seen how this will end up. So basically, you can say that the EU has indeed a lot of, trade agreements with a strong dispute settlement mechanism, but not always with the countries with whom we actually need it. But I just wanted to finally make a point on that specific issue, that obviously the EU, nevertheless, you can clearly see is managing to diffuse the situation or tackle trade disputes or irritants very often in the specific committees that are set up under these bilateral trade agreements. And you have to be quite a trade nerd and look deep into the website of DG Trade, but actually you can see that especially the last couple of years, the EU or the Commission managed to solve a lot of the trade issues before they go to actually, a panel level, but actually in a more diplomatic way in the context of joint committees that are set up by these trade agreements. And the final point that I just briefly want to add that was not really mentioned so far is everything that the EU has been doing in the area of ISDS reform, of investor-state dispute settlement reform. And obviously this is a long story, so I will be very short. But after TTIP, of course, the EU has reformed, ISDS, and has now its new investment court system in place now in CETA, and also in a separate investment agreements with Vietnam and Singapore, and recently also with the agreement with Mexico. And also very recently, the Court of Justice gave green light to the investment court system so that it is compatible with EU law. But nevertheless, the proof of the pudding is in eating. And this dish is not really being served because so far, none of these investment court systems are in force. With Canada, it doesn't follow the provision application. And CETA is still not ratified. And in the context of these other agreements that I mentioned, for example, with Vietnam and Singapore, they are in a separate mixed agreements because it doesn't fall under the exclusive competences of the Union. So these agreements will not be very popular for ratification. So it still could take a while before these agreements will, or these investment court systems will be in place. And the same applies with regard to the EU's efforts to set up a multilateral investment court system in the context of Uncitral. The EU made a proposal, but you can see that many countries have different proposals, which also makes sense. So it remains to be seen actually what the outcome of that could be. And the final point also, but this is quite specific, so I just want to mention it, that also within the EU, these investment agreements are, a lot is going on. There was recently, finally, after this Achmea judgment, the agreement to terminate investment agreements between member states, and also obviously then the ISDS. But there is still the question to what extent, or what will happen with the Energy Charter Treaty. And only last week, actually, Belgium asked a question or an opinion to the Court of Justice, to what extent actually, the Achmea case would basically terminate intra-member state disputes in the area of investment, if this would also apply to the Energy Charter Treaty. So, I don't want to go into much detail, but this is basically, I think, a few of the challenges that the EU is facing in this area.
Thank you very much, Guillaume. As I said, I'll take Joanna first and then come back to Denis. So Joanna Supinska, who is the senior trade correspondent at MIEX. Please.
Thank you, Fabian. Before I start, let me thank the EPC for inviting me to this timely discussion. I will try to contribute to it with a few comments/open questions. There are some key factors that shape trade policy. One of them is geopolitics. So probably many of us wonder to what extent the change of power in the US will influence thinking in Brussels and the EU capitals about required changes to the bloc's trade, defense, and enforcement policies. how deep these adjustments should go, given that the Trump's era of extremely unpredictable and hostile trade policy at the same time will soon be over, as we hope. So if we take for example, the enforcement regulation, which, as it was mentioned, was recently amended, but yet before President Trump lost elections in November, it seems that the temporary dispute settlement mechanism, which was included in this new regulation, might not be needed anymore, as we hear that President Biden is likely to lift the US blockage of the WTO dispute settlement body and let it adjudicate again. And there is also a question if the US, if after the US elections, the EU will still need to go a step further and put in place an anti-coercion mechanism, which was also mentioned earlier, and which was also mentioned by Commissioner Valdis Dombrovskis, that it might be proposed next year. If we assume that President Biden won't be using the controversial Section 301 and 232 actions to advance the US trade interests, and that the WTO dispute settlement system is back on track, hopefully, there will be a question whether the EU will still need this anti-coercion mechanism, which I understand might be difficult to put in place without at least bending the WTO rules. Or maybe such a defense mechanism would be still needed, but not to stand up to the US, but to the ever more aggressive Chinese trade policies, especially in the area of digital trade or high-tech development. And talking about China, I think it's yet to be seen how effective the new investment screening mechanism will be in helping the EU to shield itself from predatory Chinese investments. I think the lessons learned from application of this tool might be useful in designing the foreign subsidy instrument, which was earlier also mentioned, which is supposed to be also proposed next year, especially when it comes to the division of powers between the EU governments and the Commission. I think we all know how defensive EU governments can be when it comes to transferring the oversight powers to the Commission. And finally, many also wonder, I guess, how the COVID-19 pandemic will shape the adjustments to the EU trade policy. There is a talk of a need to build more resilient supply and stockpiling system in the EU to reduce the bloc's over dependency on one or just a few suppliers. But there is a very tiny line between what is an open and yet resilient trade system and one that is over-regulated and protectionist. So I think the EU will have to perform a very difficult task of striking a right balance between changes that are needed to make it more resilient and crisis-proof, and the need to keep the EU markets and borders open. And I don't think this is gonna be easy. So let me stop here to leave some time for the questions. I'm sure that Fabian and the participants have many good questions to ask. Thank you.
Thanks very much, Joanna. And I already see some questions coming in, so I'll come to those in a minute. But I'll let Denis respond to some of those comments. And let me add one more to that. And that's linked to a major concern which I have about trade policy, which is the acceptance in populations. And that we are seeing more and more that trade deals can be very controversial, sometimes divorced from the content, but we see that certainly globalization raises many fears. And I'm wondering whether better enforcement will help in addressing those concerns, because populations can see that the clauses on environment, on labor law are taken more seriously? Or could it not highlight that maybe these clauses are not very far-reaching and that there isn't that much in them in terms of enforcement? So I'm wondering whether you would reflect on that as well. So the floor is back to you, Denis.
Okay, but there is a matière here to do a 3-hour seminar based on all these comments. But let me try to address some of them maybe, and if not, I can come back afterwards. So then I'll start by your final point, because in a way it is an overarching question to all of this, and I think yes, very clearly, making good on what we have and what we have negotiated and being serious and systematic about it is important in order to shore up the confidence that people have in the EU's trade policy as an instrument. And I think it does play a role on this question, which I would agree with you is indeed a challenging question, of the sort of the constant need to ensure the sense of acceptability and legitimacy of the policy vis-à-vis public opinions across the EU and its member states. But I think that it starts by very simple things, this question of confidence and legitimacy and acceptability. When it comes to actually the whole question of, do we properly implement and enforce what we have negotiated? I think we have to, the best strategy is the simplest one. We have to do what we say and we have to say what we do. It's actually the best policy, normally, to convince people. So do what we say. It means that if we set a number of objectives and we negotiate certain commitments linked to these objectives, we've got to ensure they enable us to deal with real life issues and to do that in a way which is nimble enough, smooth enough, so that it doesn't take an inordinate amount of time in state-to-state discussions for us to reach concrete results. It means that if we say, look, we have an enforceable commitment and we have a breach, we have the tools to enforce them. We may, as we go along in this constant effort at effective implementation, we may discover that we have to develop new approaches or new tools. And that is actually what is already happening today. There may be more to come. Maybe we will have to review some aspects of our policy. As a matter of fact, this is why there is a revision of the trade policy overall framework right now. The commissioner, the executive vice president Dombrovskis, has also announced, as you probably know, in his hearing in Parliament, that he will also bring forward the review of what we do in the trade and sustainable development zone, and the review of what we had set out 2 years ago in a so-called 15-point action plan about what we do with the whole trade sustainable development question across different instruments. So he has decided to bring this forward, for example. So it shows that there are areas where we constantly look at improving the instrument. And then say what we do as well, because the problem is that if the stakeholder community doesn't know, doesn't understand what it is that we're doing and how we're solving problems, then we are failing. And Guillaume was saying, very few people know that a lot of the implementation and enforcement work takes place through simply investing into the cooperation frameworks that we have in place under the agreements and the various committees and so on. And I think I can agree with him. Probably this is not known and understood enough. It's very difficult to see what the different trade committees and subcommittees that we have under our agreement at a particular point in time with this or the other jurisdiction is actually producing, because there's a lot of very granular groundwork that goes into this, including in terms of diplomatic engagement in country, engagement through technical assistance and development cooperation, which is linked to the implementation of the agreement. All this is very difficult to see, and it is indeed incumbent on us to make sure that this is properly visible and projected, and there is probably a lot to do there, because again, it is granular. It is very much what we get out of the trade agreements is very much a function of what we put into them in the first place. irrespective of some of the more visible hard-edge type enforcement that you can think of. For example, going to a dispute panel. That's one out of a continuum of tools, and they're much more visible than the other ones. And as a matter of fact, a lot of the core effective implementation work takes place in such a way that you will never even know that it has taken place, because it hasn't solved a problem or an irritant that is already there and entrenched. It has prevented a problem from actually happening and impacting the flow of trade and the interests of this or the other constituency. In this respect, the WTO serves a purpose. The TBT committee in the WTO, the SPS committee in the WTO, do prevent for our economic stakeholders some of these problems, market access or otherwise, actually materializing even before they materialize. So that is part and parcel of this effort. For the rest, you mentioned a lot of things. I think some of the instruments that are going to come forward, well, we will see. They will have to be calibrated. And I would agree with Johanna that, of course, there is a balance to strike there. But as I said, our anchor points are, we want to be anchored in the rules, in the our international commitments. And we need to have tools that are proportionate to the problem that we're trying to solve, evidently. Now, when it comes to things where the Commission has not made a proposal yet, an anti-coercion, instrument, not corruption, anti-coercion instrument, or the foreign subsidy instrument, I can't tell you right now exactly how it will be calibrated. There are questions, what exactly are the triggers? What exactly are the remedies? How do they work? What's the legal basis for it? What's the scope of application? These are choices that remain, and I will not speculate on them here and today because it's premature. In terms of the logic, and that addresses also a point that was made, I think we cannot base our policy exclusively on the expectations that we have in terms of how the policy is going to evolve in this or the other jurisdiction. When it comes to a number of trade measures that the US have taken of late, say the recourse to Section 301, we do not know what will be the policy practice and whether the policy practice will be something which we consider is much more compatible with the undertakings that the US previously took in the WTO context, or whether we continue to have issues with this form of unilateral action. Very difficult to say, but that doesn't mean that we should not equip ourselves with the necessary, I would say, deterrence instruments that may be needed in any case. With the US, it's very clear that we hope that the whole question of developing the rules-based framework and reforming the WTO can be a joint project. And there are all kinds of good reasons to think that it can be the right project, including on things where over the last few years we have not necessarily seen eye to eye. I think tackling the question of the dispute settlement arm of the WTO is something where we will want to have re-engagement, evidently, with all of the main users of the dispute settlement system, and that of course includes the US. And we have always been very clear that we are putting in place some of the necessary stopgap measures, i.e. MPIA, enforcement regulation, but we keep the door open to a more structural reform of the dispute settlement resolution system in the WTO with all the players concerned. On the question of whether we have enough tools, including on the bilateral side, because we have, and Guillaume was saying this and it's quite correct, we have very large trading partners with whom we do not have indeed preferential trade agreements, where we would have a particular WTO plus type commitments and systems for enforcement. Of course, we have a relationship in the WTO. And you mentioned Russia. I mean, we have taken cases in the WTO with respect to Russia, and as a matter of fact, we did this relatively quickly after their accession, which is not something that happened, for example, with China. So we are not particularly, I think, constrained there in terms of, at the end of the day, enforcing what is enforceable with the basis that we have. In some cases, we have developed a network of trade agreements which give us something additional to the WTO, and we try to maximize the use of those aspects. In other cases, we of course are going to continue to rely on the international commitments that these countries have under the international trading system. Some of the, and just to finish off, I mean, all of these, be it new legal statutes or mechanism that we're putting in place. I mentioned the new approach to tackling barriers and compliance issues through a complaints mechanism. They have to be tested. I mean, you know, nothing is set in stone forever. We may find out that these things are either, excessive or cannot necessarily easily be used compared to the problem they're trying to solve, or on the contrary, will prove to be insufficient and insufficiently potent or powerful, in which case we will adjust. That's why there will be a constant, I would say, review of this effort in relation to the stakeholder community. So, you know, for example, when it comes to providing information through access to markets or providing an entry point through the complaint system for compliance issues, we want to hear as we go along feedback from the stakeholder community, because we want to be able to be, you know, fast enough to improve our practices as we go along, to make sure that they become more and more effective as we go along. I think that the changes in the environment are such, and I sketched out, you know, at the beginning what I think personally is a fairly bleak picture. But these changes are such that we need to be capable of adapting the policy regularly to the new environment, including when we are in an environment which is more difficult, more hostile, more confrontational. Not always the case, but it can be the case. And as EU, as a big trading bloc, we've got to be able to have the tools there and the tools ready for use.
Thank you very much. There have been a number of questions already, so I'll take 2 or 3 together and then go back to Denis. I think if either of the panelists want to come in, then please wave at me, and then I'll pass the word to you as well. But the first question I'll take from the floor, from the US, actually. Peter Ashish, if you want to unmute yourself and ask your question.
Thank you, Fabian, and thank you, Denis, for those thought-provoking remarks. As we all know, on January 20th, we're going to have a new US administration led by President-elect Joe Biden, who's a self-proclaimed Atlanticist and has spoken specifically about the need to work with allies, including on broad trade issues and facing up to the challenge of state capitalism as it comes from China. I wanted to ask what opportunities you see, or you might see, for engaging the transatlantic relationship on behalf of a more assertive, or if you will, an EU trade policy that is more effective in its enforcement. What I'm thinking of specifically would be a US-EU initiative or a US-EU-led plurilateral initiative to craft new rules and new enforcement mechanisms in the area of subsidies, which is something that you've already mentioned as an area of increasing EU concern and action.
Thank you, Peter. I'll add a couple of questions which go also into this question of international partnerships. And in particular, there have been a couple of questions on the relationship with the UK. I'm not going to ask you to speculate on the outcome of that, but clearly the UK is going to be outside the EU's common commercial policy. And there has been the well-publicized decision of the UK now to break with the EU sanctions on Boeing. So the question which arises is, what kind of relationship are we going to have with the UK in the coming years? And does it hinder EU trade policy if there's a a greater degree of divergence between the UK and the EU. And maybe I'll add another question with the other elephant in the room, which is China. And how far do you see more cooperation as well with China on some of these issues?
I can start, but I don't want to monopolize. I think that on Peter's point and on the US, as I said, we do believe that there is certainly a case for the EU and the US to work together on, as I say, on global trade issues and global trade rules, and certainly WTO reform can be a transatlantic endeavor. It can certainly be a transatlantic endeavor when it comes to filling the gaps in the WTO rule book today on some of the core level playing field issues that are insufficiently governed by the WTO today. And you did point out to this nexus of issues around subsidies that I would say more broadly competitive neutrality type issues, SOE disciplines, for example, where indeed we see that right now the net of WTO rules is a little bit too loose. And there is certainly a case for the EU and the US to try to figure out how to knit further this net of rules. We've started to do this by incubating these kinds of issues, for example, in the trilateral process with the US and Japan, on the issue in particular of how to think about augmenting the disciplines under the agreement on subsidies and countervailing measures. There's every reason to believe that this is work that could come to fruition and be brought, for example, through in a plurilateral framework under the auspices of the WTO. I can think of other issues where there can be certainly areas of cooperation and engagement with the US on global trade issues. In the area of trade enforcement, we have certain commonalities of views in terms of the fact that we want fair and sustainable trade. We have different mechanisms. We could cooperate on trade enforcement action. We have in the past. We've taken cases jointly in the WTO, for example. There's no reason to think that we will not be able to do that again. With the UK, I think, you know, that's certainly not an area which I'm going to speculate on today, I can tell you. So we'll have to see basically what comes out. I think we will enforce our future relationship when it comes to trade on the basis of how it will be governed. And in addition to that, of course, there's a question. I mean, the UK, you know, will be a member of the WTO, operating in its own rights. And I think we will probably have, between the EU and the UK, on some of these global trade issues, a lot of like-mindedness. And I think the question will be how to work on this like-mindedness going forward. With respect to China, I think we have two very different issues. We have the issues about governing the bilateral relationship, and here the negotiations are ongoing on a comprehensive agreement on investment, which is much more than a bilateral investment treaty. Is a very important initiative because that will tackle some of these level playing field issues when it comes to our interests in China, in the Chinese market. We also have to interact with China with respect to global trade issues, and in particular issues which relate not to what happens necessarily in the EU market or in the Chinese market, but in third country markets. And that can only be dealt with through global rulemaking, with China and many other players contributing to that effort. And that certainly is going to remain a big priority. As I said, you can expect that WTO reform will be very much an important zone of focus in the trade policy review going forward early next year.
Thanks very much. We are getting close to the end of the time we had allocated for that. We also had questions on more detail on the WTO, on intellectual property rights, on how measures can be coordinated among the Commission and institutions when you're looking at a range of different policies being affected. So I will give you a chance to also pick up any of those in your final words if you choose to do so. But I'll give both Guillaume and Joanna a chance to maybe have a last minute with any point you might want to choose to highlight, or any question you might want to choose to emphasize with Denis. So Joanna, if you want to go first.
I maybe would go back to your question about the perception, of public perception of what the Commission is doing in terms of trade policy, and especially the trade deals. I think what is important for the public to better understand these policies is to provide as much information as possible, especially about this most topical negotiations. We know very well what was happening during the TTIP negotiations, when some documents were leaking, and then there was this huge drama about how secret these negotiations are, because these documents are not public but should be public. So now we see that the Commission has changed its strategy and is making much more of these documents available publicly. Very fast, the Commission is publishing the negotiating papers, and I think it in a way is disarming the whole public frustration, kind of about not knowing or being disinformed about what these negotiations are about. So I think, again, this is very important to disseminate, to provide as much information and documents as possible to the public and to the journalists.
Guillaume, very briefly, so Denis has actually a chance to answer.
Well, then I will be very brief, because we've covered so many issues. So maybe very briefly on the point on that you actually raised, Fabian, on trade and sustainable development. Without going into the specifics, I mean, there's a broader question: to what extent are trade agreements really the instrument to tackle these issues? I mean, we see that the Commission is cooking up a lot of new initiatives, and I mean, with regard to, I mean, making these rules about trade and sustainable development more enforceable. We have the new initiatives or ideas coming from a joint report from the French, from France and the Netherlands. I mean, there are lots of things happening, but basically, for a lot of people, it will never be enough. I mean, this is on the one hand, of course, a political question: to what extent is really trade and FTAs the instrument to do that? But it's also a legal question: to what extent can the EU almost regulate trade and sustainable development issues and trade agreements? Because, of course, if the EU would be over-ambitious in that, I mean, the Court of Justice made very clear, then this would not fall under the competence of the EU's common commercial policy, and it would make these agreements, again, mixed, which I think we definitely want to avoid. So that's another issue, and I will, stop here and give the floor, obviously, to Denis.
Yeah. Okay. Well, look, just to conclude on my side, I mean, there were a lot of things. I don't think I can do justice to some of the questions I'm seeing in the chat, which are more specific. But I would say maybe three things. There's a question on IP. I mean, obviously, you know, we look at effective implementation and enforcement. Yes, we must look beyond traditional trading goods. Nowadays, obviously, trade agreements are deep, comprehensive, cover services, IP procurement, in particular, and in these areas, which is, you know, it's market access behind the border, and it's much more complicated, by the way, because it's regulatory in nature, not about, you know, overseeing whether country implements the reduction in the schedule in its tariff as per the schedule. This is where we need a greater effort, and this is where we need input from the stakeholder community to be able to do this, because the resources for implementation and enforcement on the public authority side are by definition limited. And there we have a lot of economic interests at play in third countries. in these areas. So you can expect that we will be putting a focus on this. Second, on the governance and transparency, what Johanna said is very true. I think it's good that she recognizes that. I think as a trade negotiation machinery, if you want, the Commission is indeed probably one of the most transparent vis-à-vis the general public in terms of all of what we have introduced, including in the preceding mandates on this issue. That has been a very, very big change. The one thing which I think we want to try to organize, and again, this is homework in a sense for people like me, is that on the whole downstream of trade policy, on implementation and enforcement, what we have discussed today, we also are not just transparent in terms of reporting, but we also find a good way to interact with the stakeholders. So moving from pure reporting to enhanced, I would say, interaction is one of the objectives that I think we're trying to set ourselves with some of the changes that we're introducing. And finally, completely agree with Guillaume, not everything can be dealt with through trade treaties. And that's normal. It's not just a question of negotiability. It's also simply a question of pertinence. You know, I'm thinking here, for example, the important international regulatory cooperation plays on trade and investment issues outside of the trade treaty framework. And there, the EU can do a lot in this area and does a lot in this area. I'm thinking about other tools which are going to make important changes in the coming months or years in terms of making European trade sustainable. For example, new due diligence frameworks directly applicable to operators. These things will become important pieces in the trade space, and they're not all going, therefore, to be associated with, I would say, classical trade treaties, but that is in the nature of modern trade and investment. I think I'll finish off on that. Thanks.
Very much. We've covered a lot of ground today. So it's not surprising that we can't go into detail on all of those. But thank you very much for coming and answering the questions and engaging with the discussion. Thank you also to our two respondents who added to the questions as well. And thank you to all of the audience for participating. Certainly trade will continue to be on the agenda. So I'm hoping to see you again very soon at an event organized by EPC or by Egmont or by both of us together. So hope to see you again very soon.
Thank you.